All right. Hi, welcome back. Attorney Steve Vondran here. Today is Saturday. I hope you guys are all having a great day, not working too hard, but not being a couch potato either. I hope you're doing something productive today. As for me, I am working on my trade secrets presentation, what I'm going to call the trade secret crash course. Now, a lot of people say, I know all the forms of intellectual property. It's copyrights, it's trademarks, it's patents. That's it. End of story. There, bingo. But a lot of people don't fail to realize that another form of intellectual property, which is basically valuable things conceived of by the mind, are trade secrets. Okay. So I put together a little presentation here. I'd like to roll through this real quick with you. This is going to help you learn more about trade secrets in the next 5 or 10 minutes than any of your peers will know. So this is great information, great around the dinner table. You say, hey, does anybody know about trade secrets? Everybody looks around and goes, what? Where's this kid learning everything? All right, so let's get with it. Trade secrets. Okay, so introduction. Here we go. So start right here. A trade secret can be one of a company's greatest intellectual assets. Just think about the Coke secret formula or Kentucky Fried Chicken's secret recipe. So these are trade secrets. Now, the thing I want you to be aware of is the difference between a patent and a trade secret. Now, when you have a patent, you could have you could basically seek what we call a limited monopoly. 20 years, I think it's 20 years for the patent. And then once the 20 years is up, the rest of the public can use the invention and do what they want, copy it, do all these kinds of things. But a trade secret could potentially last forever. So like the Coke recipe, the secret recipe, the secret formula, it's hidden in a vault somewhere. I'm just saying, it's under very close scrutiny, under very close watch. The Kentucky Fried Chicken's secret recipe, 11 herbs and spices. Remember heard that? What are those herbs and spices? We don't know. We can speculate, but I mean, there really is nothing like that first bite into a Kentucky Fried Chicken original recipe for Attorney Steve. Oh, I'll tell you what, that is for me. But it's a trade secret, meaning nobody knows. And as long as these companies take reasonable steps to protect their trade secret, it could last forever. And that's what's unique about trade secrets. That's why it's so neat. Essentially, it's anything that is kept secret that derives value from not being generally known in the marketplace. Okay, all right. So main two types of trade secret theft. Okay, so what we're talking about is when you take someone's trade secret, you steal it. Here's an example. Say you work in KFC. And you came there and you're under a non-disclosure agreement because you get to work with the secret recipe. Maybe you're one of the cook engineers or whatever it is. And you eventually leave one day. A competitor, Attorney Steve Chicken Stand, says, hey, I'm going to hire you away. Come over here. I want to get your experience and your knowledge. Come over to me. I'm going to pay you handsomely for your knowledge. Okay. So where this trade secret can get dicey is in those situations. The departing employee. Sometimes it's the employee that wants to start a new business. He says, I know everything. I'm going to go start my own business. Why would I let them make all the millions of dollars off me? I'm going to do it myself. So that's one way trade secrets can be misappropriated. Another way is what I call failed collaborations. This is where two parties get together, they start working on something, they agree things are trade secrets, and then one says, I'm out of here, this isn't working, and they go on to do something, of a competing brand or so. So that's kind of a general nutshell what trade secrets is. If all you want to know is the general nutshell, just hit the stop. You'll be done here. You can say, I know a little something, okay? It's up to you. You want to take a deeper dive? Let's go. Under California law, I put source of law. There's basically two sources of law. One is your state law. California has a statute. Almost every state has a statute that covers trade secrets. I think there were only two, and I don't want to speculate on which ones they were. I think maybe it was New York. I just can't remember. But most states have adopted the Uniform Trade Secrets Act, what we call UTSA. I don't know if that's how you pronounce it, but that's what I call it. So you have your state law. We have the California statute. I'll talk about that in a second. But you also have federal law. About 3 years ago, they passed a federal law for federal trade secret theft. I think what they called the Defend Trade Secrets Act in 2016, signed by President Barack Obama. Okay, so what is a trade secret under California law? Here it is again, what we just talked about. The UTSA, the California Uniform Trade Secret Act, which is in, let's just find out where that's at here. California Civil Code, you can see it right here. California Civil Code Section 3426 is your trade secret act in California. It defines trade secret to mean any information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential value, from not being generally known to the public or to other persons who can obtain economic value from its disclosure or use. And also is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. And there's our code section. I was looking for that. So there it is. So it's a lot of different things. It can be a lot of different things. And it has to be subject to reasonable efforts. If you're not taking reasonable efforts, you're just letting employees come and go, and you're not really putting much effort into it, you may not have any trade secrets, okay? So these are the general requirements. Let's go down to types of things that may be protected. This is just a short list I put together. Secret formulas and recipes. You don't need something tangible, does not have to be tangible. Customer lists, it does not need to be something technical in nature. It can be very simple. It can be a compilation, number 3, of information that may otherwise be public in nature, public source. 4, can be valuable information, any valuable information that provides a competitive business advantage by not being generally well known. Technical designs, research and testing, know-how, those kinds of things. Computer source code can be protected as a trade secret. They also seek software patents on it. Product information, data sheets, sales forecasts for the company, pipeline reports, business and marketing strategies. Okay, so, think about it. So if you work at Nike, you're up in Oregon, you work at Nike, and you have the access to all the mass amounts of data that they probably have on shoes and shoes buyers and where they're from and what they pay and what kind of marketing works best. That's valuable knowledge. And if people are keeping that secret, that can be very valuable. And big companies, Fortune 500 companies, they don't want this stuff leaking out, nor do a lot of the smaller companies. So that's kind of, this is, again, it could be anything, but that just should help you out a little bit, okay? Now, how do you take care? How do you do number 2 here? Give reasonable efforts to maintain secrecy of your trade secret. That's a question. So let's go here. How to protect a trade secret so it can potentially last forever. That's what we're talking about. Here are some of the most important steps. 1, take reasonable steps to protect it from disclosure. Use of non-disclosure agreements. Number 2, labeling things. Whoops, I put labeling as a trademark. I'm putting label as confidential and a trade secret. Okay, so if you're giving documents confidential, it's labeled as such. Providing access to the information or the trade secret on a need-to-know basis, not providing access to everybody in the company. Need-to-know basis is a good one. 5, police and enforce your trade secrets, pursue your theft cases. In other words, take these serious. When you have an employee that's leaving with all your information, that may be something you have to take action on, okay? Number 6 is monitor internet activities, especially things out of your network, email, texting. I have on here somewhere employee training, number 9. But a lot of this ties in where you want to train your employees on trade secrets, what your confidential proprietary information is, so they know. You don't want to leave this to chance. You want to explain to people that we have proprietary confidential information. A lot of times this can be done through an employee manual, an employment contract, those kinds of things where you're identifying the things that you consider to be a trade secret, okay? So education of your employees is important. The monitoring, sometimes employers will monitor their employees and people say, oh my God, it's privacy, it's privacy. Well, I'm sorry, but usually when you go to work I'll just tell you, in California, the case law has come down, that the case law that I've read has come down that say you don't really have a reasonable expectation of privacy at work. You have a reasonable expectation that you should be working and not sharing trade secrets. So anyway, but employee education, monitoring employees, physical security, such as video monitoring. I'm sure some companies where you have their super secrets, there's probably security guards, there's probably video cameras, passwords, the use of, as we have here, number 8, electronic security, firewalls, keystroke loggers. That's what you install on a computer. You can see what people are typing, so somebody's not going, here are our company trade secrets, send. So it allows you to monitor that, source code tracking. Number 10, exit interviews. This one I think is really important. And this is, when obviously sometimes you have to terminate people and it doesn't work out and they have trade secrets. You may need to sit them down, go over the trade secrets, explain to them what it is. I know there are employers out there that will pay severances to make sure that they're getting an agreement to keep everything quiet, and then even giving them some money to do it, just to make sure they're the set extra consideration if you watch my contract videos. So that can be a very important one to make them know, because sometimes an employee that's leaving, they're upset, they don't, they're angry, they want to get revenge, or they want to show you that you were wrong or something. So I think this is really important. Annual audits is another one. You can audit your company on an annual basis just to make sure we're going through the steps. You can have a checklist and things that you're doing. And number 12, pre-employment background checks on your employees and screening. Again, you want to make sure. It costs a little money to do a background search. I don't know how much, but I think a couple hundred to a couple thousand. And you want to know who you're bringing into your organization to potentially expose these trade secrets to. So a good background check, to me, very important. So those are some things you can do that when you need to go into court to litigate a trade secret case, the judge says, well, what reasonable steps have you taken? You go, well, here's my list. Let me show you. We got this. We got videos. We got password. We got manuals. We got non-disclosure agreements. We limited, blah, blah, blah. Now you're looking good. Okay? So I'm not going to go through this. You can look, if you want, some definitions under the California Civil Code, what it means to improperly misappropriate a trade secret. I'll just read this real quick. It includes theft, bribery, misrepresentation, breach or inducement of a breach of a duty to maintain secrecy or espionage through electronic or other means. Reverse engineering or independent derivation alone shall not be considered improper means. So this talks a little bit about, somebody obtaining the trade secret by improper means. Okay, so let's go down a little. You can come read that if you want. Let's go down to the jury instructions. So say you get into a case in California anyway, and there's a jury instructions that go to the jury. Here's the rules that you're going to be looking at. Tell us whether you think the plaintiff has met the burden of proof. If you don't know what burden of proof is, Google my video, Attorney Steve Burden of Proof. It's a great video. But here's what you're going to have to show. Plaintiff bears the burden of proof usually in a civil court lawsuit. Here's the jury instructions in California. CACI 4400. Okay, there's your jury instruction. Plaintiff claims that he or she, the owner / licensee of insert general description of the trade secret. So plaintiff owns the trade secret, number 1. Number 2, plaintiff claims that these something trade secrets were misappropriated by a defendant. That's number 2. 3, plaintiff also claims that the misappropriation caused him or her harm or defendant to be unjustly enriched. Okay, so trade secrets, misappropriated, unjustly enriched, or harmed. Okay, so there's your elements. I mean, that couldn't be much easier, right? That's one of the easier cases, I would say, again, when you're pleading your case, you're going to want to document your facts, your allegations. You're going to be talking about your trade secret in general, and you're going to be talking about. I mean, and by the way, you're not going to want to disclose your trade secret on the complaint. That's something that you're going to have to work out so that you're not disclosing everything through your complaint. So these are your elements. You're going to show your damages. Now they took my idea. They're competing and they're making $10 million a year. Now they're unjustly enriched. Now they're doing better than we are. You know, turns out they knew how to. It was my trade secret, but it turns out they know how to run a company better. You know, those kinds of things. All right, so that's that. Now let's get down to the Federal Trade Secrets Law, the Defend Trade Secrets Act, signed by President Obama in 2016. Again, I'm not going to read this, but I'm going to go down here. This does not preempt the state law, but it does add safe harbor for whistleblowers. There's a little blurb by the American Bar Association, and here's a little section on the remedies. Generally, remedies is going to be your damages. Under federal law, there may be some seizure opportunities and, you know, of course, seeking an injunction. Now down here, if you come down a little bit more, you can see here if the trade secret is willfully and maliciously misappropriated, exemplary damages in an amount not more than 2 times the amount of damages can be awarded. So say the jury comes back and they say it's $5 million. If you can show that it was willful and malicious misappropriation, 2 times. You can get 2 times that, okay, as a punitive damage. Section D, if it's willfully and maliciously appropriated, reasonable attorney fees may also be available. So that's a brief overview. Real quick, damages can be very high. You can see some of these awards here, $919 million, $2.3 billion, $940 million. I mean, just some huge, huge cases. So that's a real brief overview. You can check out the rest there if you want, but that's more than most people will ever know about trade secrets. So this is going to be a wrap. Attorney Steve, I got to get running, have some friends coming over today. And if you like this video, give me the thumbs up. Any comments, leave them below. We appreciate you watching. Have a great weekend. If you need help with a civil litigation case, intellectual property, trade secrets, copyrights, trademarks, give me a ring. You can find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. Have a great week. We'll see you next week.